Please remain standing.
Please join me for the Pledge of Allegiance when they get all in the room. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. Mr. Hart.
Thank you, Judge. Welcome, high school seniors, to Law Day. I think we have Escambia County, Escambia Academy, and Atmore Christian Schools represented here today. We appreciate, first of all, I'm Jim Hart, and I'm president of the Escambia County Bar. We appreciate everyone who has helped make Law Day possible. School administrators, attorneys, judges, public officials, staff, students, and others. It takes a team working together to make Law Day possible, and we thank you. A special thanks to Attorney Charles Godwin, who has run our Law Day program since the early 90s. He has done a fantastic job, and we thank him. Now, a little bit about Law Day. Law Day was established in 1958 by President Eisenhower. It's celebrated May 1st of every year. Today marks the 65th year of Law Day. It's noted as a day for national dedication to the principles of government under law. The purpose of Law Day is to have people learn to appreciate their liberties, to reaffirm their loyalty to the United States, to have people seek the ideals of equal justice under the law in relation to each other and other countries, and to show how cultivation of respect for law is vital to our democracy. We are a nation of laws. Without laws, there's anarchy. The Law Day theme for 2023 is Cornerstones of Democracy: Civics, Civility, and Collaboration. Civics is the study of the rights and duties of citizens. Civility is caring for your own identity, needs, and beliefs without degrading someone else's in the process. Collaboration is working together to reach a common goal or objective. Agree where you can agree. The right to vote in our country is more than just a right. It's a civic responsibility. Voting determines who represents us and makes laws in our representative republic. We vote for local, state, and federal officials who represent us. This is how we have government by and for the people. People have a civic duty to serve on juries. Civics is a citizen's link to government, and it's very important. In court, there must be order, or nothing else can get done. You can't have people blurting out in court. You got to have one at a time speak, or else you are out of order. In the legislature, there must be order. People need to get along, even though they disagree, or have different viewpoints on what government should do. We must have civility for our government systems to work. In our system of justice, the majority of cases, whether they be civil or criminal, are solved by settlement. People reaching common ground and agreeing to resolve disputes. In this way, people have to collaborate to resolve disputes without trials. Our system of justice depends on collaboration to operate. The legislature and our representatives try to reach common ground where possible on important legislative functions. Now, I know there's a lot of gridlock in our legislative system and everything, but they still have to reach common ground and collaborate where possible, or government would grind to a halt. So, collaboration is necessary for the functioning of our democracy. Now, our law day program is a real deal trial. There's going to be a state and defendant as parties. We're going to have district attorneys. We're going to have defense attorney, judge. We're going to have a court reporter taking the record. We're going to have jurors selected to hear the case. And jurors are going to be the finders of fact. The judge will give the jurors the law. Jurors will render a verdict. Verdict means to speak the truth. Escambia County's law program has been in existence since the early 80s. Our law day features, as I said, an actual trial by jury. And some of you students are going to be jurors. This is a real case. It's a real defendant. And the state and the defendant are interested in the jury's verdict in this case. Now I'll ask the attorneys to stand up and introduce themselves, and I will start with Charles.
I'm sorry.
Oh,
I'm sorry. I just,
This is Charles Godwin. He's who I was telling you about, who's been in charge of our law day since the early 90s, and he's done a fantastic job, and we appreciate it.
Good morning, I'm Danny White. I practice law here in Escambia County and surrounding counties. I have an office here in Bruton. I'm also the public defender for the city of Bruton, and I'm also the municipal court judge for the city of East Bruton.
Good morning, I'm Ernie White. I practice law with my daughter, Sierra White. The law firm is White & White. We're here in Bruton. We both live in Wilmington.
Gordon Godwin, I practice in Atmore. I also went to school at the academy in 7th and 8th grade. I graduated from ECHS in '93. But I have a private practice in Atmore, and I'm also your public defender for Atmore, your public defender for Flomaton, and your public defender for East Bruton.
Mike Perry, I'm an attorney here in Bruton. My office is located directly behind the courthouse.
Good morning. I'm Steve Billy, and I serve as your district attorney.
Good morning, I'm Tim Godwin. I have an office in Atmore where I practice with my father, Charles Godwin, and I'm a 1986 graduate of Escambia County High School.
Good morning. My name is Jeremy Hawkins. I have a practice here in Bruton. My office is right across the street.
Good morning. My name is Kareem Reynolds. I'm a proud graduate of Escambia County High School. I have an office in Atmore. I serve as the county commissioner, and I'm also the municipal judge in the Atmore community.
I'm Wade Hartley. I serve as the public defender for the Escambia County. I'm Joe Witt. I practice at Thompson Garrett Hines here in Bruton with Brooks Garrett, Kurt Garrett, and Ed Hines. I'm also the Atmore City Prosecutor and the Flomaton Municipal Court Judge, and I'm an assistant district attorney.
I'm Ben Brown. I serve as assistant public defender for the county.
I'm Pettis, and I'm an assistant district attorney.
Good morning, I'm Melissa Grosso, and I practice at Otts-Moore in Bruton. We have an office in Bruton and one in Atmore, and I'm also an assistant district attorney.
Good morning, I'm Eric Coleman, district judge, and I'll be speaking to y'all a little bit later.
Aaron Watson, I own the Watson firm in Pensacola, Florida.
All right, thank you, attorneys and guests and judges. I would like to recognize VOPs who contribute and make Law Day possible. Sheriff Heath Jackson, who was chosen as by the 66 sheriffs in the state as treasurer for the Alabama Sheriff's Association. Ms. Michelle McClung, superintendent of Escambia County Schools. Mr. George Brown, assistant superintendent of Escambia County Schools. Michelle Collier, assistant superintendent of Escambia County Schools. Dr. Kenneth Varner, Superintendent of Bergen City Schools. Dale Ash for Pepsi. Webb Nall, retired Pepsi employee. Newspaper publishers, Atmore News, Atmore Advance, Tri-City Letter, and Bergen Standard. Escambia County Commission, Escambia County School Board, Bergen City School Board, participating private and homeschool teachers and administrators. I'm now pleased to introduce our speaker, Attorney Aaron L. Watson. He is a graduate of Florida State University. He graduated from Stetson University College of Law in 2009, receiving his Juris Doctorate. He also attended the University of Granada in Granada, Spain, in the study abroad program, where he studied international litigation and comparative law. While in law school, he was involved in the Advocacy Board trial team, which won a national championship in the spring of 2009, defeating 248 teams from 148 law schools. Quite impressive. Mr. Watson was voted most likely to be in the library by his law school graduating class. I know what that's about. Personally, Attorney Watson, professionally, Attorney Watson was a former shareholder with the firm of Levin, Papatonio, Thomas, Mitchell, Rafferty, and Proctor from 2009 to 2016. Currently, Mr. Watson is the owner of the Watson Firm, PLLC, from 2016 to the present. Attorney Watson's law office is in Pensacola, Florida. He was named to the top 20 most influential people in Pensacola in 2021. He was named to Florida Super Lawyers Magazine in 2020 and 2021. He was named Entrepreneur of the Year by the Streeter Business Institute in 2019. He was named Top 100 Black Lawyers in the United States by the National Black Lawyers from 2018 and 2019. Attorney Watson has been involved in numerous multi-million-dollar settlements and verdicts during his impressive law career as a civil litigator. He is a lecturer on various aspects of civil litigation. He is a member of the $1 Million Advocates Forum, which comprises only 1% of U.S. lawyers who are selected. He is an inductee into the National Trial Lawyers Top 40 Under 40 in 2014. He is a member of the Phi Beta Sigma fraternity. He is a motivational speaker. He's a songwriter, musician, and a choir director. He is co-founder of the Watson Family Foundation, benefiting local families. Please join me in welcoming Aaron L. Watson.
Good morning, everybody. Good morning, everybody. Good morning. What time is it? 9 o'clock. I know everybody's still asleep, but certainly I want to thank the bar, everybody who put this great event together for doing this again. You know, it's a wonderful event. I believe this is my third year speaking at this event, and each year when I get the call, I get excited about it because I get a chance to motivate and inspire future lawyers, future professionals, and some of the folks and young folks in our community, including members of our bar as well. You know, Law Day is important. You know, it's important to see and learn how this justice system works and how it operates. And so I think you're going to have a rare opportunity today to get to sit in on a trial, on a case, and it's going to be exciting. So I have about 15 minutes to say something to you all, and I like to try to inspire whenever I speak. I certainly always, you know, I'm thankful and grateful when I hear someone introduce me of what's happened along in my journey as a lawyer. You know, the successes I've had, in the courtroom. You know, we just had a $5 million settlement a few months ago against a trucking company out of Canada. We sued Yamaha, got $12.6 million. Excuse me, $3.3 million. Sued a trucking company out of New Orleans, got $12.6 million. You know, it's been a fight for justice since I started as a trial lawyer. But when I was in your shoes, I just had dreams about being a lawyer. You know, I don't come from money. I don't come from lawyers. I'm the first one in my family. I'm the second person to graduate from college. You know, this wasn't something that, you know, I could call my dad and ask how to prepare for the bar exam. You know, my dad is a preacher. My mother's a secretary. You know, when they said I was most likely to be in the library, it's because I didn't know what I was doing, and I figured if I just stayed in the library and just kept reading those books, that something was going to stick. And it did stick. You know, at the end of the day, you know, although I drive a nice car, you guys saw the Rolls Royce parked outside. It was a Bentley last year, the Rolls Royce this year. I got a new one. You know, I fly all around the world. I've been to Indonesia. My wife and I celebrated our 10-year anniversary in Bali last year. We're getting ready to go to Egypt in a couple weeks. Fly out to Vegas tomorrow. You know, there's something really cool about education. There's something really cool about finishing school, you know, that you can achieve your dreams. And it might seem like it's tough. I don't come from money. I come from a rough community, as did I. I had friends who got shot and killed in my community. Car had been broken in several nights in my community. I remember having friends come and tell me, we were playing football, let's go break in somebody's house in my community. I didn't, because I made smart decisions. I knew I had big dreams. I knew I wanted to be something. I knew I wanted to give my kids a better life than what I had. My kids, I got 2 twin boys, they're 6 years old, but I put them in the best school I could possibly put them into. You know, my little girl, Mia, she's 2-year-old. I just bought her a Burberry dress the other day, and I was thinking, as she was riding in the back of our car, I was like, man, you know, the life that they're living. You know, we used to wear clothes that the church used to put in garbage bags, hand-me-downs, that they would give to us to wear to schools. You know, we used to call the shoes Bobo shoes. You know, I can't even tell you the name of the shoes, but clothes would sometimes be faded, have holes in them, but that's what my parents could afford. But I said that I'm going to give my kids something better, and I'm going to work hard, I'm going to dream big in order to do that. Here's what, the message I want to leave with you today. Is, you know, at the end of the day, I'm a country boy. You know, my family grew up in Scuba, Mississippi. You probably never heard of it before. It's near Meridian, Mississippi. And I remember my granddad one day teaching me how to build a fire. You know, we had, my father had moved from Scuba to New York. We were city kids, but my dad would let us stay in Mississippi each summer, you know, to kind of get a dose of that life. And I remember he would tell me, he said, Aaron, you know, listen, when you want to build a fire, you know, you got to take special attention, you know, to building and growing this flame. You got to make sure you start out and put the right wood on it, because you put green wood on this fire, it's going to go out. You put some kindling, some tinder on the fire, you know, we can get this thing to grow. So I said, I want y'all to go out and go grab some wood, let's see if we can get this fire to grow. So I go out looking, trying to find some wood for this fire, and I put this big green wet log on there. My granddaddy said, boy, are you not listening? You don't put wet wood on fire. Put dry wood on the fire. And that fire will grow and grow, get so big you can't even put it out. Can't put a water hose can't put it out. But you got to make sure you pay special attention to your fire. Each and every one of you have a fire inside. It's your dream. As you heard me talking about a dream today, I'm sure you thought about what your dream was. It's a small fire right now, but you have to pay special attention to make sure that fire doesn't go out, because the winds can blow it out, the rain can blow it out. You can put out your own fire, so you got to make sure that you're monitoring what you're putting in your fire, the type of wood that you're putting on your dreams. I've learned in my life that, you know, some of the wood that I found that was the driest, that would really cause your flame to grow, is when people tell you no. When people tell you no, you might think to yourself, you know what, man, that's discouraging. No, when people tell me no, that's adding a piece of dry wood onto my fire, because it only increases that flame in the inside. The problem is when you tell yourself no. That's that green wood I was telling you about. When you start telling yourself no, you can't do it. I can't be a lawyer. I can't be a judge. I can't be a teacher. I can't be a professional. That's that green wood that's going to put your fire out, and nobody wants to see a burned out fire. We can't do anything with a bunch of smoke, but we can do something with some fire. And I thought about when I was in high school, when I told my teacher I wanted to go to Florida State, I wanted to go to college. She said, Aaron, you don't got the grades. No, you don't have the grades. You've been sent to the dean's office too many times. You know, you can't go to college. I applied anyway. I said, even though I don't have the ACT scores and the SAT scores and I don't have the GPA, I'm going to apply anyway, because she put a piece of wood on my fire, that no wood. And I applied anyway and got in. Thank God I got in. And then I kept progressing, kept going. I figured out that I was really good with arguing. I love to argue. I love to win. I love to debate. I started applying to law school. And when I looked on the law school's website, they said the law school costs $30,000 a year. It's a private law school, you know. And so I didn't have the LSAT score. That's a test you got to take to get into law school. And I didn't have the GPA. I looked at that website. That website was telling me no, but I applied anyway. I applied to Harvard. They didn't let me in, but I applied anyway. Because I feel like when people tell me no, that's just telling me to go ahead and do it anyway. You're not going to tell me no to my dream. You're not going to stop my dream. So I applied anyway. And I got in. And I got into at that time, it was the #1 school in the country for trial advocacy. That means if you want to get into the courtroom, you want to advocate, that's the best school in the country. And I wanted to apply to their trial team. That's where they put the best and the brightest law students against other law students. When we get in this courtroom, we try cases against each other. I tried out for that trial team. They told me no. They said you ain't good enough to be on our #1 trial team in the nation. So I applied again the next semester. Worked even harder at it, and guess what? They let me in. And you know, when they let me in, they put me in a national competition to compete against 140 law schools. I did not lose a single round. By the time I graduated, I was the #1 advocate in the country. You know why? Because they told me no, that I couldn't do it. I remember when I applied to this big law firm called Levin Papantonio to work with this legendary lawyer, Fred Levin. His name is on the University of Florida's law school. I applied to the law firm. They said, no, your grades ain't good enough. Your bar exam isn't high enough. So I said, you know what? They told me no, that ain't nothing but some wood to put on my flame. And I'm starting to notice that my fire is getting stronger. It's burning even higher because these folks are telling me no, no, no. So what I did was I applied. They said no. I called the newspaper, told the newspaper, hey, you know, I just won this big national competition. I'm from Pensacola. Y'all should run it on the front page. They say, okay. I called my dad. I said, do we have anybody at the church that works at this law firm? Oh, yeah, Miss Gwen does. I called Miss Gwen. I said, can you put this paper on Fred Levin's desk on Monday when the paper runs? Within an hour, I got a call from Fred Levin himself asking to come and meet with me to offer me a job. I tell you, I can't take no for an answer. You tell me no, that's just going to put gasoline, going to put some more of that dry wood on my fire. I remember when I met my wife in Atlanta, I was there in a deposition. We talked on the phone for a couple months, 2 or 3 months, and I started to have a liking for her. I said, you're my dream girl. You look like Beyonce, you talk like Beyonce, you smell good, you look good. And I asked her to be my girlfriend. Guess what she said? I like when you tell me no. That just means I got to do even more. I got to start buying you flowers. In fact, she told me that I was her best friend. I was in the friend zone. Y'all ever been in the friend zone before? But I got out of that friend zone real quick. I had to take her for a couple of steaks, watch a couple of good movies. But lo and behold, she's my wife now 10 years. We got 3 beautiful kids together. But no is what inspired me to keep on going. I remember at the time I made shareholder at the Levin Law Firm. I was the first African-American shareholder they've had since 1954. Something was in my spirit that said, you know what, you can open your own law firm. You know, you can go and start a law firm. You're just as smart. I know you don't have too many business owners in your family, but you know, I always tell folks when you look at another person and they can do it, you ought to take that as motivation. If you can do it, I can do it too. You know, I'm just as smart. As long as you got a brain just like I got a brain. You know, I studied for the bar exam, passed it. I had a Juris Doctor degree. What makes them so different from me? I decided to jump out there and quit my 6-figure job. I talked to my wife and said, I believe I need to start my own law firm. The next week after I quit, I found out she was pregnant with twins. I said, oh, Lord Jesus, I'm about to go back into my firm and tell them I was just playing. I quit the job. The news covered it. They said he made a mistake. People walking up to me around the community, you made a mistake. Within 3 months, I had my first $1 million settlement in the mail. Within 2 years, the firm became a $1 million company. Within 3 years, a multi-million-dollar company. Each year, it's continued to double. We went from 1 employee to 2 employees to 15 employees to 20 employees to 30 employees. I got 5 lawyers working for me now. Because they told me no, I couldn't do it. So what is my message to you today? When somebody tells you no, that means go harder, okay? When somebody tells you no, you're not smart enough, no, you can't do it, that means go harder. Don't let anybody tell you no. And remember that Mr. Watson said, keep that fire burning. Thank you so much.
You know what Mr. Watson was saying got me thinking about things, about you guys are going to be graduating soon. I want you to know when you get out in life, it's okay, you know, to make a mistake. It's not like school where everything's a test. If you make a mistake, what I'd like to see you do is fall forward. Then you can come back and get up and start over again and reach your goals. Now I'm going to dismiss the attorneys. And I'm going to turn over the program to Circuit Judge, Honorable Circuit Judge Jeff White, and he will talk about the rest of the program and the case.
Thank you, Mr. Hart. Good morning, everybody. This thing on? I'm Judge White. I'm the presiding circuit judge here in Escambia County. I'd like to personally welcome you to our program. Appreciate what the bar does to make this happen. It's not the judges' program, it's the Escambia County Bar Association. We appreciate their efforts. We're going to move along and get the case going here, but first of all, I want to introduce some important people to the process here in Escambia County. To my right is Circuit Judge Todd Stearns. Judge Stearns and I are the circuit judges, and our primary responsibility is to deal with felony criminal cases, the higher level civil cases, domestic relations, divorce cases, and that sort of thing. You met Judge Cole earlier. Judge Cole is our district judge. His primary responsibilities involve juvenile court, dependency, delinquency, traffic, lower level civil cases, and misdemeanor offenses. However, we are all cross-deputized, for lack of a better phrase. We all deal with everything because of the caseload that we have. Judge Stearns may hear a small claims case. I may hear a juvenile case, depends on what we have going, but those are our technical alignment of responsibilities. Some other important people to the process I would like to introduce is our court personnel. And to my right down here is Ms. Patrice Bradley. She is miraculously recording everything I say. I still don't understand how that works, okay, but she does. I can ask her to transcribe something, and it's always there. I would like to introduce the person with the most seniority in our judicial staff, even though she don't look a day over 25. Ms. Denise Carley. She is our other court reporter. She works primarily for Judge Stearns. Denise has been here quite a while. We don't even get into the years, but we appreciate the job that she does. Ms. Jody Wilson, I'll ask her to stand. She is my judicial assistant. Ms. Linda Young right here. Linda is our jury coordinator. Ms. Monica Clayton over in the corner. Stand up, Monica. Monica's like me. She's virtually challenged, so our running joke is when I ask her to stand, she says, I am standing. It's a wrong joke. Okay. Carrie Powell. Okay. And you met Sheriff Jackson. Sheriff Jackson, you met him. So these are important people to the process up here. We appreciate what they do. And I don't know what's wrong with the sound system, but fix it, please. At this time, I'm going to excuse Judge Stearns. He has a lot of work to do. We appreciate Judge Stearns. He will be presiding over the case tomorrow. Our new sound system. This sound system was installed about a month ago. Anyways. At this time, I'm going to ask my judicial assistant to go find the prosecution and the defense and get them in here. And I want to talk to you a little bit about the jury selection process, okay? I'm going to try to speak up. All right, the way we usually choose a jury is we contact the administrative office of courts. Can everybody hear me okay?
Yes, sir.
Can you hear me? The administrative office of courts is the entity that deals with all the courts in the state of Alabama. And we would say we need 250 jurors for our June term. they would automatically send out notices to 250 Escambia County residents, and then those people would hopefully show up for jury duty on the specified date. The way those are selected is by a computer algorithm, and your name is in the database if you possess an Alabama driver's license or a picture ID. All right, it has nothing to do with being registered to vote or any other process. If you have a driver's license or a picture ID, you are in the database. All right, that's how we get the jury venire. That's called the venire when we have the big group out here. Okay. Now, what we've done today is we have selected the jurors out of your names as randomly as we could, and we've got students from each school that's represented on our jury, and we're fixing to seat you here momentarily as soon as we get the lawyers in. But understand, normally there would be a jury selection process, and contrary to what a lot of people believe, you don't get to select who you want on the jury. You get to eliminate those you least want on the jury, all right? So we would start off with a panel of probably 36 people, and I would give the lawyers the opportunity to ask questions of our venire, and then we would have a session where we would call it the striking of the jury, and each side would strike somebody they didn't want on the jury until we ended up with 12. That's how it would normally work. But again, today we have eliminated that for the purposes of time, okay? I will tell you that, like you've heard from Mr. Hart, this is a real case with real consequences. This young lady is a real person, so it's real, all right? So we're going to try to move it along. Let me get back to my notes. At this time, Mr. Fountain is going to call the names. Gentlemen, you are going to have to relocate. We're fixing to seat our jury. We'll ask you to go into the witness room. Mr. Fountain is going to call the names of our jurors. There's going to be 14, I believe. A standard jury is 12. However, we have 2 alternates identified. The alternates will not be specifically identified until the jury is allowed to retire and deliberate. So the alternates will not know who they are. You will not know. Only I and Mr. Fountain know who the alternates are. But before you begin your deliberations, the alternates will be released. So at this time, if you hear your name called, please stand up, come through these swinging doors, and Jody, we need a bailiff up here. Which one of y'all will be the bailiff? Officer Porter is going to be our bailiff. Officer Porter will direct you and enter the jury box, go all the way to the end. Thank you, Officer Porter. At this time, Mr. Fountain, if you would call the names of our jurors.
Judah Dennis. Brianna Gaines. Daniel Ganaka. Takara Lambert. Charles McGill. Tiffany Gookin. Anaya Redmond. DeAndre Richardson. Trinity Thames. Isabella McGee. Claire Gerby.
She's not here today.
Not here? Okay.
All right. Sydney Mast. Justice Zundale. Elliot Klassen. Garrett Harper. All right, Judge, you got everybody.
We got 13.
Huh? I got 14.
Well, one person wasn't here.
Yeah, but I replaced them with that one. Dylan would know.
I forgot to introduce the most important person in the courthouse. And that would be me. No, not Mr. Fountain is our circuit.
Mr. Fountain is our circuit court clerk, all right? Mr. Fountain's job is to manage all of the cases here in Escambia County, from small claims all the way up to $1 million civil cases and Class A felonies. And Mr. Fountain and his staff do a wonderful job, and Mr. Fountain accept my apologies for forgetting, okay?
You got it.
So, thank you, Mr. Fountain. Also, Mr. Webnall's in the back. Y'all have heard his name mentioned by Mr. Hart, but I want to extend my personal thanks to Mr. Nall and Pepsi Cola of Atmore. Mr. Nall has been a part of this program since I certainly can remember. He is retired now, but every time I see him, he's working, so I don't know how that's working out for him, but we appreciate it, Mr. Webb. Thank you for what you do. Okay, back to my notes. All right, this time I'm going to administer the oath to the jurors. So if you'll please stand for me, all of you. And each of you raise your right hand. Do you solemnly swear or affirm that you will well and truly try all issues joined between the defendant and the state of Alabama and render a true verdict thereon according to the law and evidence, so help you God? You do? Everybody acknowledge in the affirmative? You may be seated. At this time, I'm going to introduce our attorneys for the state. We have Ms. Grosso. Ms. Grosso is lead counsel. She's an assistant DA, and Mr. Joe Witt is also an assistant DA assisting today. We have Mr. Corinne Reynolds, who is a defense attorney from Atmore. He is defending Ms. Alexis Crenshaw. Ms. Crenshaw is in court today, and ordinarily they would get to ask you questions and that sort of thing, but because of time, we aren't going to do that today. Let me give you some preliminary instructions, all right? All evidence comes from the witness stand. You're going to hear witnesses today. You're going to see evidence. All of it comes from here. None of it comes from anywhere else. You are the trier of fact. There may be objections during the trial that I will rule upon. You should take nothing from the way I rule. If I rule against a party or for a party, that means nothing to you. Those are issues of law which are my prerogative, my responsibility, not yours. You are the trier of fact, okay? And at the end of the case, I will tell you what law to apply to the facts that you come up with based upon the evidence. Do not do any independent research. Let me stop right there and talk to you about our cell phone policy. Put your cell phones away. If you have them out during court, they will be taken away from you till court's over, all right? If you have to use it for an emergency, you can go through the back doors and use it, but do not have it out in court. Turn it off or turn it on vibrate. For our jurors, when you go on break, you may check your cell phone, but do not do any independent research on your cell phone. Don't look up the meaning of terms. Don't try to search the lawyers. Don't try to search the witnesses, anything like that. That is completely improper and would result in severe consequences if it's done, okay? Do not discuss the case during the break, all right? You're going to hear evidence. We're going to have a break. You're going to come back and hear some more evidence. You can't talk about what you've heard while you're on break, all right? You can talk about anything else, but don't talk about any of the evidence. Do not interact with anyone during the break other than you as jury. You can't interact with anybody out there. When we have a break, you'll be sequestered. You'll get your snacks and your drinks. You do not interact with any of your friends or acquaintances during the break. The way the trial works is the state will be given the opportunity to make opening statements. Now, what these statements are, what they expect the evidence to show. The defense will follow with what the defense expects the evidence to show or not show. And at that time, we will begin the testimony. After the state has presented its witnesses, we may take up some motions, and then the defense will be entitled to present their evidence, all right? At the close of the evidence, we may take up other motions, and then they'll be given the opportunity to give closing statements. The closing statements are intended to argue what the evidence did show or did not show. At the close of that, I will charge you as to the law that you will apply to the case, and then you will be excused to go deliberate to obtain a verdict. That's kind of the compressed version of what's going to happen, so you kind of know what's going to happen. All right? Let me go to the attorneys at this time and ask the state any preliminary issues you think I've missed. Ms. Grosso?
No, Your Honor.
Mr. Reynolds, anything you think I've missed so far?
Negative, Judge.
All right, at this time, I'm going to turn it over to the state for their opening remarks. Ms. Grosso, the floor is yours.
Yes. May it please the court? Good morning. I am Melissa Grosso, and I'm an assistant district attorney. So I work for Mr. Steve Billy, who is your county district attorney. And we thank you for being here today and participating in Law Day. It's very important for the seniors and for this county and for our bar association. The case today is kind of different. It's kind of new for our county. The charge is unlawful possession of a controlled substance. And that controlled substance is edibles. And I think most people probably have heard of edibles, but that's not something that we see around here very often. So what we expect the evidence to show is that last Monday, on April the 24th, Ms. Crenshaw was in Atmore, and she was stopped at a checkpoint, driver's license checkpoint. And the officer smelled the odor of marijuana, and at that point, he had probable cause to search the vehicle. So he searched the vehicle, and in the center console, he found edibles. And you'll get to see the video that shows the interaction. You'll actually get to see the edibles, and you'll get to see photographs that show that it was THC edible, and it was called popcorn. So she was charged with unlawful possession of a controlled substance, and today we would ask that you find her guilty.
Mr. Reynolds?
All right, good morning, ladies and gentlemen of the jury. My name is Kareem Reynolds, and I am the attorney for the accused, Ms. Alexis Crenshaw, right here. My job here today is simple, is to defend my client to the best of my ability and to expose the great miscarriage of justice right here in front of us. Now, you may have learned some of this stuff in your social studies classes or government's class, but the framers of our great nation foresaw the potential of warrantless searches and seizures by government officials, and their solution was simple. It was the Fourth Amendment to the U.S. Constitution, which prohibited government officials from unlawfully searching your home, vehicles, and persons. Now, keep that in mind while I tell you about today's case. Today in front of you, ladies and gentlemen, we have Miss Alexis Crenshaw. She is a resident of Atmore, the Porch community, and she's a former student, not that far removed from school. Now, there's a few issues. She's charged with possession of a controlled substance, which is the marijuana edibles, which was found in the vehicle. There are a few issues that we're going to address, two issues to be exact. The first issue is whether there was an illegal search of the vehicle. Now, the question of admissibility of evidence is not for you guys, it's for the judge. He controls all the evidence that comes in and out of the courtroom. But I just want to put this thought in the back of your head while I tell you about today. The general rule is that any illegally obtained evidence is not admissible to prove guilt. Now, what we expect evidence to show in trial today is that on April the 24th, around 9:30 p.m., law enforcement officers set up a checkpoint in the Atmore community, Freemanville community, across from the Fast Lane gas station, if you're familiar with that area. Evidence will show that my client was traveling on Jackson Range Road in a vehicle that she had borrowed from a friend when she was stopped at this checkpoint. While passing through the checkpoint, sheriff deputies requested the driver's license. There was a little back and forth between the driver and the law enforcement officers on the scene that day. And it ultimately resulted in officers searching the vehicle. Now, the purpose of this checkpoint was driver license compliance, but they ended up searching her vehicle. Now, what is probable cause? You heard Ms. Grosso, she stated that the officer smelled marijuana, and that was his probable cause for searching the vehicle. What is probable cause? That's a certain set of facts and circumstances that would lead a reasonable person to believe that a crime has actually been committed. To justify his search of the vehicle, the officer, evidence gonna show that the officer said he smelled marijuana, and that's why he searched the car. However, there was no marijuana found. There was marijuana edibles, and the label on that was popcorn. So I assume, I'm not familiar with edibles, maybe you guys have heard of it, but I don't know how much of a marijuana scent that edibles have. So, and keep in mind, the purpose of that point was not to check for drugs, it was just to check for driver license compliance. The next issue is whether the defendant actually possessed the controlled substance under Alabama law. In this case, evidence will show that the defendant did not have the marijuana edibles on her person. She did not have it in her pocket. She did not have it in her coat. She did not have it in her purse with her driver's license, any of that thing, or any of those things. Evidence will show that the marijuana edibles were found in a vehicle that did not belong to the defendant. And she was not the only person to have control of that vehicle on the day of the incident. And I'm gonna ask you guys, how many of you have actually borrowed somebody's car? How many of you drove your parents' car or your brother's car to school today, or any day this week? How many of you actually go through that car, check the glove compartment, check the console, check the trunk, and make sure there's no illegal contraband in there? The law is clear. This could happen to any one of you guys who drive a friend's or family member vehicle. The law is clear. In order to convict a person, there has to be knowledge that they knew the controlled substance was in that location. I ask you to pay attention to all of the evidence that's presented here today and find the defendant not guilty of possession of a controlled substance, because in our opinion, she did not even know that the drugs was in that vehicle, because it was simply a loaner vehicle and she was making a short trip in someone else's vehicle. Thanks, ladies and gentlemen.
Thank you, Mr. Brown. Ladies and gentlemen, I kind of omitted something that you obviously know now, that the charge is unlawful possession of a controlled substance. And it comes through a complaint. Ordinarily, this set of circumstances would be presented to a grand jury. That's a jury of 18 who are convened to determine if probable cause exists to indict somebody. What you should understand is the parties have agreed that they will proceed without that indictment. Just because the defendant has been charged does not mean that she is guilty of anything. Like I said, all the evidence comes from the witness stand. The charging document means nothing. It's still the burden of state to prove beyond a reasonable doubt the defendant is guilty. Okay? So at this time, Ms. Grosso, you prepared to call your first witness?
Yes, Your Honor.
All right, call your first
The
witness.
state's going to call Jacob Baker.
Jacob Baker. Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I swear. Have a seat, speaking to the microphone, your witness, Ms. Grosso.
All right, state your name for the court.
Jacob Baker,
And where are you employed?
Escambia County Sheriff's Office.
And what are your duties with the Escambia County Sheriff's Office?
I'm a K-9 patrol deputy.
Okay. And how long have you worked with the Sheriff's Department?
Escambia County 4 years.
Can y'all hear back there? Everybody hear? Yeah. Thank you. Thumbs up. Thank you, Mr. Rooney. I'm sorry, Ms. Grosso.
That's okay.
Oh, they can't hear her?
Yeah, that's what I was saying.
Can you move that over to your podium, Ms. Wilson, or?
Can everybody hear me, or no? No?
Thank you.
Okay. All right, is that better?
How's that?
Okay, good. All right. So the question was, how long have you been employed with the Escambia County Sheriff's Office?
4 years with Escambia County.
Okay. And you were obviously employed back on April the 24th of this year,
Yes, ma'am.
which was last Monday, correct?
Yes, ma'am.
Okay. And were you on duty that day?
I was.
And did you assist Alabama State Troopers in a driver's license checkpoint on that day?
Yes, ma'am, I did.
And tell the jury what time of day that was.
I believe we started around 8:30 or 9 p.m.
Okay. And where was that checkpoint?
It was at Jack Springs Road near Daly Street, right there at the Fast Lane gas station.
Okay. And did you have chance to come into contact with the defendant in this case?
Yes, ma'am, I did.
Okay. And is that Alexis Crenshaw?
Yes, ma'am.
And is she seated at counsel's table?
Yes, ma'am.
Okay. Can you point her out to identify her for the court?
Right there.
Okay. All right. And so Ms. Crenshaw stopped at the driver's license checkpoint, correct?
Yes, ma'am.
Okay. And she rolled her window down?
Yes, ma'am.
Okay. And what was the first contact, or what was the first thing that you asked her?
As soon as I made contact, I asked her for a driver's license, and while speaking, as soon as I was saying that, the strong odor of marijuana was emitting from the interior of the vehicle.
Okay. So as soon as you made contact, you smelled the odor of marijuana?
Yes, ma'am.
Okay. Was she able to produce her driver's license?
She was not.
Okay. Did she have a driver's license?
I believe, I don't recall what she said, but she did not have it on her at the time.
All right. Did you make any observations of Ms. Crenshaw?
I noticed when I was speaking to her, she had a green leafy substance on the front of her shirt. And I did ask her if she had had any marijuana. She voluntarily told me she smoked some earlier.
Okay. So you smelled the odor, you saw the substance on her shirt, and she admitted to smoking marijuana earlier.
Yes.
Okay, what did you do next?
I then pulled her over to the side to have her talk with Trooper Smith about the license situation, to see if she was suspended or revoked, or just not, or did not have a valid driver's license. While I didn't conduct a probable cause search of the vehicle based on odor of marijuana.
Okay, so you said that she pulled over to the side?
Yes, ma'am. We pulled them into the gas station off the roadway for safety.
Okay. Is that the Fast Lane gas station?
Yes, ma'am.
Okay. And so she pulled over. Did she exit the vehicle?
Yes, ma'am. I asked her to step out.
Okay. And once she stepped out, what did she do next?
At first she was very cooperative. Then she got on the phone and it increasingly she got uncooperative. I've asked her several times, just for officer safety reasons, to not be on the phone. And then she began to get on the phone and discuss, I guess, the traffic stop. And she was explaining to the people that we were stating that we smelled marijuana and we were just searching the car. She acted like we were doing it for no reason. So I then told her, I said, if you want to stay on the phone, you need to be truthful or who you're on the phone with.
Mm-hmm. So she was telling that to whoever she was talking to?
Right. Now I'm not sure who she was speaking to, but who she was speaking to, that's what she was saying.
Okay. At that point, was she being questioned by the state trooper?
I believe about the license situation.
Okay. And when she was with the state trooper, which is Travis Smith, correct?
Yes, ma'am.
What were you doing?
I was doing the probable cause search.
Okay. So tell the jurors again, what gave you probable cause to search that vehicle?
The odor of marijuana and the green leafy substance believed to be marijuana all over her shirt, and her stating she smoked marijuana prior to that.
Okay. So you did the search of the vehicle. What areas did you search?
Around the driver's seat area, and once I made it to the center console, that's when I located the substance.
Okay. Let me ask you this. Was there anybody else in the vehicle other than Ms. Crenshaw?
Nobody else.
Okay. All right, so you searched the driver's area, and then you searched the center console.
Yes, ma'am.
Okay, and what did you find in the center console?
It was a black sealed packet which had a label of popcorn, and it had a printed cannabis leaf label on it, and also comes with a label telling you the THC content of it. And I don't recall what it was I know it did have 0 CBD, which just ran up to him.
Okay, I want to show you what's been marked for identification purposes, State's Exhibit 1. If you take a look at that. Okay, will you tell the jurors what that is?
So it's basically, the brand is banned, it's THC infused popcorn, full spectrum. It's the white cheddar flavor. The THC content is 105.48 milligrams. CBD was 0%. The serving size is 1 to 10 of the bag. It comes with approximately 4.5 kernels. And then in the bottom of the label, which is hard to read, it explains how much is in each kernel.
Okay, but this is a photograph of what you recovered from Ms. Crenshaw's center console.
Yes, ma'am.
Okay, and this photograph was taken that night, correct?
Yes.
Okay, and it hadn't been altered in any kind of way?
I believe Trooper Smith took it in the patrol unit that night.
Okay, but this truly and accurately reflects what you found in the center console?
Yes, ma'am.
Okay, Judge, we would move to admit State's Exhibit 1.
Any objections?
No objection, Judge.
States 1 is in evidence.
Judge, we would ask to publish this to the jurors.
Granted.
So you did say, you were reading off the bag, but you did say that the bag indicated that it was THC infused popcorn.
Yes, ma'am.
It's POTCORN.
Yes, ma'am.
Okay. And the bag did indicate that the total THC is 105.48 milligrams.
Yes, ma'am.
And that one of the ingredients listed on the bag is full spectrum cannabis distillate. Okay? And the bag also indicates that there's 0% CBD. Okay. I want to show you what's been marked as State's Exhibit 2 for identification purposes. Is that an up-close picture of that
Yes, ma'am.
bag of popcorn?
Yes, ma'am.
Okay, so that picture clearly shows you what the ingredients are.
Yes, ma'am.
Okay. All right, Judge, we would move to admit State's Exhibit 2.
Any objections, Mr. Reynolds?
Negative, Judge.
States 2 is in evidence.
Judge, we would ask to publish this to the jurors.
Granted.
All right, after you found the popcorn in the center console, what did you do next?
Once I located it, I was actually reading it. I've never run into that popcorn before. I ran into other forms of edibles, and it was kind of intriguing. I was reading it while walking towards Trooper Smith and the defendant, and she made a voluntary statement, that's not marijuana, that's edibles.
Okay, so, so she knew that that was in her vehicle?
Yes, ma'am.
All right, or otherwise she wouldn't have made that voluntary statement that those are edibles.
Yes, ma'am.
And if she had no knowledge that that was in the vehicle, then she wouldn't have made that statement that that's edibles. Would you agree? Okay. All right. Did she make any other statements?
Not that I recall.
Okay, and was she compliant during this?
Initially she was, then she became very irate with us, not really wanting to cooperate, not wanting to get off the phone, and it just went downhill from there between her and the trooper.
Okay. How long would you say the encounter with Ms. Crenshaw was?
I don't really recall, it'd be probably less than 20 minutes.
Okay, all right. And at some point she was placed under arrest?
Yes, ma'am. Trooper Travis Smith placed her under arrest.
Okay, and she was charged with unlawful possession of a controlled substance?
Yes, I believe that, and driving under the influence.
Okay. And Did you transport her to the Escambia County
No,
District?
Trooper Smith did.
Okay, all right. And after she was transported, did you have any other involvement in investigation?
No, Trooper Smith took over he took possession of the popcorn and he transported her to the detention facility.
Okay, all right. So at that point, your involvement was over?
Right, yes, ma'am.
Okay. All right, Your Honor, those are my questions.
Cross, Mr. Brown?
Hey, Officer Baker, your testimony is that you were operating, working with the state troopers at the checkpoint on that night?
Yes, sir.
All right, and what was your job on this night?
Just to assist, that's a very high traffic area, just helping check driver's license. If I know somebody else is checking my driver's license, I'd walk around the back of the car, check, make sure the registration was good, give them a thumbs up.
And were you the first officer to make contact with Miss Alexis Crenshaw on this day?
Yes, sir.
All right. And your testimony was that you immediately smelled the odor of marijuana?
As soon as I made an approach and the window was down, yes, sir.
You also testified that you saw marijuana on her shirt.
It's very residual amount of shade, yes, sir.
Did you confiscate that marijuana?
I did not.
Was it enough to confiscate?
It probably was not. It would probably just, when they were trying to get an evidence bag, it probably never happened.
Was it a crumb or a seed? Or?
It was just residual marijuana.
What does that look like? Can you explain to the jury what that residual look like?
It's the shade is very fine amounts from where it spills out, how they're smoking it or doing it.
I'm pretty sure they got the same questions I got. Can you make the motion of how large that marijuana may have been that you saw?
I can't. It's residual.
Would it be that big or that big?
I don't want to give a false size to the jury.
Can you see it with the naked eye from a distance?
You can. You see it with the naked eye.
If I had
Not from a great distance, but up close with a bright flashlight, yes.
If I had it on my shirt, would you be able to see it?
From this distance, on a white shirt, possibly.
But you didn't confiscate it, you didn't charge it with that marijuana?
I didn't charge it with the edibles either, the trooper did.
Okay, all right, so the marijuana edibles, let's go back to the search. You indicated that you searched it based on probable cause, you saw the marijuana.
But on odor of marijuana.
Did you investigate, whose vehicle was it that she was traveling in?
I believe she said it was her girlfriend's.
Did you verify that? Did you investigate that?
The trooper wrote the ticket. I didn't run any type of license or the tag, so I couldn't testify to that.
Okay. Did you run it, well, the trooper testified to running the tag?
The trooper ran the driver's license tag
And you also stated that you found marijuana in the compartment?
Edibles.
Edibles?
Marijuana edibles. Yes.
When you said a compartment, the console, is that the little thing in between the seats?
Yes, sir, the center console,
Okay.
outside the driver's seat.
And when you searched that vehicle, did you have to pull anything out of the console to get to it, or was it?
I looked in the center console and it was sitting directly on top.
Okay.
I think there was a paper just beside it, but it wasn't covered up or anything.
And what led you to believe that that belonged to the defendant?
She was the only one in the vehicle when she was operating the motor vehicle.
And that's the only reason you say it's hers?
Yes, sir.
Is there any other evidence that you have, other than her driving that vehicle, that would lead the jury to believe that that marijuana belonged to her?
Yeah, as far as marijuana edibles,
Marijuana edibles. All right.
that she was the driver of the vehicle.
Okay, so if those drugs actually belong to the owner or some other friend who operated that vehicle prior to the defendant, you wouldn't have no way of knowing that whether it belonged to someone else with you?
I would not.
And you also testified that the defendant was initially cooperating.
She was.
And then she became irate.
Yeah, irate, just kind of being, just kind of resistant towards not listening.
Are you aware that that incident was filmed?
Yes.
So in that video, we'll see an irate defendant.
You'll see someone that will not get off the phone after being told numerous times.
So she won't be cooperating with law enforcement, in your opinion?
Yes.
But we will get to see that video.
Yeah, as far as I know.
We will. And you also indicated that the defendant, you also made another statement that the defendant told you that they were just edibles.
Right.
Did she tell you that?
When I was walking up, I want to say, she said, that's not marijuana, that's edibles, if I recall. It'd be on video.
Okay, okay. So that will be on video.
I have not been able to review the video, but I'm quite sure she was standing close enough to the trooper where it should show up.
Okay. And other than her operating the vehicle, you have no firsthand knowledge to indicate that those drugs actually belong to the defendant?
Right, sir.
Are you familiar with edibles?
It's something we're starting to run into a lot more, but through my 10 years in law enforcement, this is becoming a new thing.
Okay. Based on your experience, can you smell it? Does it have a marijuana smell to it?
The edibles, I'm not sure. I know marijuana does.
Or do they smell more like whatever they're trying to mimic, such as popcorn or candy? Do they have those smells?
To be honest, with the fentanyl right now in the state of Alabama, I'm not smelling anything, not even marijuana up close.
All right, plaintiffs on the state's exhibit 1, 2, and 3, they all show the marijuana edibles in some sort of packaging. Is that correct?
That's correct.
They also have barcodes on them. Is that correct?
Yes, like little QR code.
So, these edibles had to be legally obtained somewhere. Is that correct?
Well, depending on how you want to say legal, if you purchased it in California or another state where marijuana is recreational, then it'd be legal. If they purchased here in Alabama, it'd be illegal.
That's what I mean. Based on the evidence, it looked like it came from somewhere, a legitimate place. Is that correct?
Yes, sir. It's manufactured by some company.
It is illegal in Alabama?
Yes, sir.
And you charged her based on the package that said THC?
The trooper charged.
All right. We're not disputing that these are not edibles, but I'm just trying to.
Oh, no.
But they were obtained somewhere.
That's correct.
So if a friend was visiting from somewhere else and that car belonged to them and they from another state, they could have been in the vehicle.
That's correct.
No further question.
Redirect.
Deputy Baker, I'm sorry, Judge. Mr. Reynolds talked about the marijuana that was on the shirt, what we call shake. But she wasn't charged with that, correct?
Yes, she was not.
Right, she wasn't charged with possession of marijuana, that being a green leafy substance.
No.
Okay, and she could have been charged with that.
Yeah, we probably could have pushed that issue.
Right, but she was only charged with unlawful possession of a controlled substance, that being that popcorn, correct? Okay, and, again, she ID'd that popcorn as being edibles as you approached with it, correct? So that did indicate that she had knowledge that that was in fact an edible. Okay, those are my questions.
Cross.
It was in a package, correct?
It was in a package.
If you hold that package up today, I would be able to tell you that it's marijuana edibles. Is that correct?
Would you be able to tell?
Yeah.
If you read the label.
All right. If we pass that the state's exhibit 1, 2, and 3 to the jury, they will be able to tell that it's marijuana edibles on those pictures.
If you read the ingredients and you see the marijuana leaf that's stamped on the bottom, I would hope most people, and that's what's dangerous about the edibles, is some people do not know. If it's out of this package form, I will be the first to tell you, if it was in a Ziploc bag, you would not know if it was marijuana edibles.
Exactly. And the defendant, she identified it after you took it out of the vehicle.
Right, I was walking up, I thought it was marijuana. I think I even told the trooper, I said, that she was being uncooperative. I believe I made a statement, I said, here's some marijuana right here, and as I was reading it, that's when she made the voluntary statement. I said, that's not marijuana, I said.
Okay, thanks.
But before she made that statement, she didn't have a chance to read it. You didn't show it, you didn't put it right in her face and let her read it.
I was across the parking lot.
Okay, so she wouldn't have knowledge that that was in fact THC infused popcorn. She would have had that knowledge prior. Right, okay, thank you.
Further questions, Judge?
You step down, officer. Thank you. May he be excused, counsel?
Yes, Judge.
Yes, Judge.
Be excused if you need to go off. Any other witnesses?
Judge, Your Honor, we're gonna call Travis Smith.
Travis Smith. You swear affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God. Yes. Have a seat, speak into the microphone. You're a witness, Mr. Russo.
State your name for the court,
Travis Smith,
and where are you employed?
I live at the state troopers.
Okay. And how long have you been a state trooper?
I've been with the troopers 6 years now, with 11 years total law enforcement.
Okay. And what are your duties as a state trooper?
We enforce basic traffic laws as well as impaired driving and drug enforcement laws.
Okay. So a lot of traffic?
Yes,
Lot of
highway patrol.
Okay. And I'm assuming you were employed back on April the 24th, which was last Monday?
That's correct.
Okay, as a state trooper. And were you on duty that day?
I was that night.
Okay. And did you conduct a driver's license checkpoint that night?
That's correct.
Okay. And were you assisting a driver's license checkpoint, or did you actually set it up?
I set that one up.
Okay. And tell the jurors a little bit about the procedure that you take when setting up or initiating a checkpoint.
So you choose a high traffic area where you feel like you'll be able to enforce laws pretty regularly, where it's also safe to do so. So you don't want to go to a major intersection with 2 guys and get run over. So that particular night, we chose Jack Springs Road near the fast lane gas station out there. And I had some Atmore officers as well as Escambia County deputies meet me out there. We'll set up, you have to have a procedure in place to check either every car, every other car, whatever your plan may be, you stick to it. So that particular night, we checked every car that came through between 9 and 11. And you wear your reflective vests, have flashlights, and have your lights on.
Okay. And did you have any other law enforcement agencies assisting you?
It was Atmore Police Department and the Escambia County Sheriff's Office.
Okay. And the jurors previously heard from Jacob Baker with the Escambia County Sheriff's Department. Was he there that night?
He was.
Okay. And he was assisting you?
He was.
All right. And did y'all have an opportunity to come in contact with the defendant, Alexis Crenshaw?
Yes.
Okay. And is she seated in the courtroom?
She is.
Can you identify her for the jurors?
Yes, that's Ms. Crenshaw.
Okay. And she approached the driver's license checkpoint, correct?
Correct.
And did Deputy Baker make first contact with her?
He did.
Okay. And the jurors have heard from him. He testified, as you know, previously. But tell the jurors when you came into contact with Ms. Crenshaw.
I was seated in my vehicle after running a ticket to someone who came through with no driver's license. Deputy Baker was to my right where Ms. Crenshaw was, and he called my name. I looked over at him, and he pulled her to the parking lot. I got out of my car, approached her. At that point, he's asking her to exit the vehicle. She was covered in green leafy marijuana and smelled of marijuana.
Okay. And was she the only one in the vehicle?
She was the only occupant of the vehicle, yes.
All right. And so she approached you.
When Deputy Baker had a Ford side roadway, asked me to come to them, I called her to come to me, so he could search the vehicle when she stood where I was at.
Okay, and once she came to you, what happened next?
She stood by my passenger door, and I began talking to her. At that point, she pulled her cell phone out. She had previously told us that she was had marijuana on her. When she pulled her cell phone out, she starts calling a friend of hers, making it out to be like we made this up, saying that we're saying she's got marijuana, that we're saying she's doing this. And at that point, we asked her to get off the cell phone, and Jacob Baker had found a bag of what we believed was marijuana at the time, and approached my vehicle where she was at, and we told her we found marijuana. At that point, she says, that's not marijuana, that's edibles.
Okay, all right. So did she have a chance to look at that packaging, that kind of package of edibles before she made that voluntary statement that it was in fact edibles, not marijuana?
When Deputy Baker approached both of us, it was the back side of the packaging, which was black and plain. There was no label on it. I couldn't read what it said. She couldn't see what it said, but she told me that was edibles.
Okay. And That's on your body cam video, correct?
Yes.
Okay, and the jurors will be able to see that interaction, right?
Yes.
All right. So was it obvious to you that she had prior knowledge that that in fact was edibles?
Yes, she knew what it was without even being able to read the label.
All right. So what happened next?
At that point, again, she was still on the phone trying to call somebody to come to the checkpoint with us. We asked her again several times to put the phone down and the phone up. She wouldn't listen. She continued to walk around the area. She just appeared to be under the influence of marijuana. She appeared dazed, and at that point, I took her phone from her, and then we placed her in arrest for possession of controlled substance, which is the THC in the edibles.
Okay, all right. And I want to show you what's been admitted as State's Exhibit 1. Can you tell the jurors what that is?
So the label says that it's banned THC-infused popcorn, P-O-T, corn, popcorn. Inside the packaging is what it looks like, popcorn to a doctor in the store. On the label, it tells you that a dosage of each kernel, half a kernel is one dosage of what someone is recommended to take, and that half of a kernel contains 105 milligrams of THC.
So would you say that that is potent?
That is an extremely high dosage, yes.
Okay. That's more than you would get from smoking marijuana in the green leafy substance form.
And that can change from whichever strand you would have, but that is a very high dosage on average.
And did you have a chance to field test the popcorn?
Yes, I conducted a NARC-2 field test on it, which would, if it was positive, it would give a gold or yellowish color, and that was the result.
Okay. I want to show you what's been marked as State's Exhibit 3. Take a look at that. And tell the jurors what that is.
So what, can I have a comment? So this little plastic test kit here, you insert a small portion of whatever the product may be into the cylinder here, and you activate the first cylinder, allow it to soak the product up, and then you activate the last cylinder, which reacts with it, which will give you either the negative or the positive result. And in this case, we got the positive result.
Okay. So it did in fact test positive for marijuana.
Or for THC.
Or for THC. Judge, we would move to admit plaintiff's State's Exhibit 3.
No objection, Judge.
Stage 3 is in evidence.
And again, the interaction that you had with Ms. Crenshaw, it was recorded on your body camera.
That is
body
correct.
cam footage. And I want to show you what's been marked as State's Exhibit 4. Is that your body cam footage from that night?
Yes.
Okay. And you've had a chance to review this footage?
Yes.
And it hasn't been altered or amended in any kind of way?
No.
And it truly and accurately reflects what happened that night?
Yes.
Okay. Judge, we would move to admit State's Exhibit 4.
No objection, Judge.
Stage 4 is in evidence.
Judge, we're going to ask to publish State's Exhibit 3 to the jurors.
Okay, that's granted.
And permission to play, you might get it set up while they're looking.
No objections to publish. Okay. Granted.
I don't know if they'll be able to see it.
Maybe we can show it to them after the trial, maybe if we have time, but Judge Cole's got.
of marijuana, right?
Okay, that's fine. As long as you ain't got no bag of weed on your person, correct? Okay, you just spoke earlier.
You come on, man, okay?
Just call that trooper real quick.
Hey, look, you got any weed in there, tell them to throw it out first.
No, I smoke. Hey, it's on my shirt. I ain't gonna lie.
Is there anything on you?
No, it's on my shirt.
Put your pockets inside out? All right, you want suspenders, you said? All right, hang on.
She said she just got an ID.
That's fine. All right, come over here, man. You ain't got to go phone right now, you good? You in good hands right now. You ain't going to jail for a little bit of weed, huh?
No, I ain't got no phone. I ain't got no weed.
Right here, right here.
There's a roadblock down the road.
Why you telling on us?
They searching the car. They told me I had weed in the street. It's down in my family. Maryland.
We done got her, man. She stopped.
He's talking about I got weed in the car.
We ain't talking about you talking about. You better tell the truth right now.
Oh shit! I don't tell the truth, bro.
I'll put you in there right now. Tell the truth.
Yeah, tell the truth. Tell people on the phone the real truth.
Yeah.
About how we smell weed and you told me it's all over your shirt.
No, I said it's on my shirt.
And now we got weed. And now we got weed.
That's not weed, bro. That's edible. Like, look, you know the edible.
Oh, that's a controlled substance thing. That's a felony.
Go ahead and hang up the phone if you don't mind.
Yeah. You done. You done.
She ain't here.
You done. That's a felony.
I said because it's on my shirt. I'm not.
Let me see what you got.
It's on my shirt. I smoked it.
It's popcorn?
Yeah, it's legit actually possible.
Banned. The lunatic is banned.
Anytime you tell me I'm jail,
Nobody said you could go. You could already be in handcuffs for an investigation.
This is a straight up felony. What this is.
but that's why I forgot to make a call. But like the weed and stuff, like I smoked that.
Then why'd you go on the phone and start painting the bad guy? Yeah, but you talking about that we saying this,
I'm
we saying
saying
that.
he's saying I got weed on my shirt. I know the call.
Then tell the truth. Say yes.
I know what's in her car.
What I'm saying is that you do use marijuana.
I said I smoke. What?
Then chill out. You're
I
fine.
smoked weed earlier.
Then chill. Chill out. You tripping. You just high. Chill out.
I'm not.
No, so.
Earlier. Just get on my shirt.
Come over here. Come here. There at the door. Case number.
I've never seen an actual popcorn. I've seen like all the candies.
Popcorn. Look at the milligrams of THC on there. That is high. Like one kernel is like all you need.
It's actually got cheddar cheeses.
That would mess you up, bro. Come on.
Which one you want?
How old are you? What you gonna do, deputy? Where you go? You're a sergeant yet? Are you anything? Just came out.
But they went there, right? And I knew they went right. They were on that.
Did you have anything you want to turn around? Want to turn around? I ain't running yet, call liquor.
You haven't charged anything before?
Hey, listen, focus on me. Come here. Hang that phone right now.
I can't.
Why can't you?
Like, she on the way to me.
You still have your phone up.
I'm going to
Hand me the phone. Yeah, you're going to. Give me the phone. Because right now you belong to us, because you are. Hang the phone up.
Man, hurry up, bro.
You know that's right.
Because you won't pay attention.
You're telling people to come here.
And you're not focusing on what we're trying to tell.
You're driving.
Because you will not focus on what we're trying to talk to you. This is serious. You need to be in handcuffs. He needs to charge you, honestly. But you're not paying attention because you're so high and you're not respectful and you're just drifting around. You're driving her car, bro. You got drugs in her car, bro.
You've not listened to me. And you were talking until you got out of the car. And then all of a sudden, you're trying to
Now come here. Because you wouldn't listen. Come here. What is your social security number? Quit taking your pants. Quit. Put your hands out of your pants. What is your social security number? Stop that. Don't charge me. Can't think back. Because you're acting because you're a toddler. Because you make the rules here. You control. You the boss, right?
It's not that. I'm just saying what she's doing. All y'all here wait till my people come.
No.
It's her car.
They ain't have work.
I know what I'm doing.
Walk with me. Walk with me. Walk with me. Because you're too high.
I'm not high.
She ain't able to. Gotta see. That's another drug. Hop in. Yeah, it's just another driving license. Explain this process to her.
What was that about?
She's just high. The thing is, though, if I take her, we're done.
Pass the witness, Judge.
Mr. Reynolds? All right, good morning, Mr. Smith. Just a few questions. Now, Officer Baker had testified that the defendant was irate. Was she irate in that video?
I would have as irate.
Okay. Was she cooperating with you?
She was passive. She was passive resistance towards us.
All right. I saw that you put the cuffs on her.
Yes.
Did she resist?
She did with her left arm, tried to pull away from me, and then she extended it as hard as she could.
Okay.
I did not charge her with resisting arrest.
Okay. Also saw a moment in the video where you asked her to get in the car. Did she get in the car with her? Did she get in the car? Did she give you any problem when you asked her?
I had to actually force her to walk towards the back of my car, yes, sir.
All right, and also the Officer Baker testified that he was halfway across the parking lot when he held up the marijuana edible bag and the defendant identified it. Is that true?
I don't know what his measurement was. When he held the bag up, it was the back side of the bag, and she identified it without being able to read it.
Okay, let's see if we can put this in perspective. The operating area where your car was located at and the defendant's car, was it the size of this room?
It was smaller than that area.
It was smaller than that. So y'all were actually operating in a real small space, is that correct?
If I had to say, her car was probably around that first benches over there.
Okay, that's pretty close, isn't it?
This depends on what your reason for measurement is, however you determine that.
Well, one thing that I noticed is that Officer Baker also testified that she identified the marijuana edibles when he confronted her with the marijuana. He said he held up the bag and she identified it as, that's not marijuana, that's edible.
That's correct.
Okay, we heard that in the video.
Yes.
But he was pretty close when he held that bag up, wasn't
I'm just matter of respect.
he? And you also heard on the video, you indicated that the defendant was high.
Yes.
And that's why she went incorporated. What symptoms of under the influence did she display on this date that would lead you to believe that she was under the influence of some kind of foreign substance?
So she initially had the red bloodshot eyes. She had the debris marijuana on her. She had the odor of marijuana. Her behavior where she's having a hard time comprehending what we're asking her to do. Several times in the video I've asked her to stand by my door. She continues to drift and linger around. Several times we asked her to hang the phone up. She just continues to not do it. She's not comprehending. I'm a drug recognition expert where I've seen all the indicators of impairment, and I did not do any field sobriety on her. I didn't think she was able to do it.
Okay, but you asked her to step out of the vehicle, she done that.
Yes.
You asked her to put her hand behind her back, she done that.
She gave me one hand and she did try to pull the other hand away.
You asked her to get in the vehicle after she was arrested, she done that.
I had to drag her there, yes, sir.
What did she not do that you asked her?
Judge, I'm gonna object to whether or not she's cooperative is not relevant to whether or not she unlawfully possessed a controlled substance.
Response? We withdraw the question, Judge. The Trooper Baker also said he made the decision to testify her based solely on the fact that she was the sole operator of that vehicle on that day. Is that correct?
Could you repeat that?
Officer Baker indicated that you guys made the decision to charge her with possession of the controlled substance based solely on the fact that she was operating that vehicle and she was the only operator of that vehicle. Is that correct, based on your investigation?
I would add that plus her knowledge of it being in the vehicle, yes.
Did she admit, I was listening to the video, I didn't hear it. She said she didn't.
In the video, she says, I forgot that was in there.
I didn't hear that. But I'll leave that to the ladies and gentlemen of the jury. What I heard is that, I heard her say, that's not mine. But I could be mistaken. Did you investigate to ascertain who the vehicle belonged to? Did anyone ask the question, who vehicle does this belong to?
She told me it was her girlfriend's car, fiance's car, and then we actually allowed the fiance to come and take possession of the vehicle.
And again, just for the jury, the marijuana, the edibles was not found on her person. It was not found in her pocket. It was not found on her jacket, her purse, anything of that nature, was it?
It was not.
It was found in someone else's vehicle that she was actually driving.
That's correct.
And you're telling the ladies and gentlemen of this jury that in that video, she admitted that that was her edibles.
She says, I forgot that was in there.
But she also said that it was not hers. Is that correct? Did you hear that?
I don't.
I'm a defense attorney. I may have heard. I did hear it. I also heard in the video about her having marijuana on her shirt. Did she actually have marijuana on her shirt, or was she talking about the scent of marijuana on her?
No, she had actually green leafy marijuana residue on her shirt when she first exited the vehicle. And then she actually grabbed her shirt and kind of knocked it off her.
She's not on trial today for that, is she?
No,
She's on trial today based on the edibles that was found in that vehicle.
the possession of controlled substance, yes, sir.
And my last line of questioning is that it is true that the vehicle did not belong to the defendant. Is that correct?
That is true.
It is true that the packaging of that controlled substance, it had to be obtained legally somewhere, though not in the state of Alabama. It would have had to been purchased somewhere legally, based on the packaging. Is that a fair?
I can't speak on that. She could have purchased off the street from somebody who obtained it illegally.
Okay. So most of the time when you see, based on your experience in dealing with edibles or marijuana or any foreign controlled substance, do they bear that type of packaging? Or do Are they like in Ziploc bags or something?
It varies. You can get some, that kind of package, you can get it in a plastic bag with no label on it. You can get it in a liquid form, a powder form, a candy bar form. It comes in all types of variations.
And as the trooper investigating this incident, you can't verify that the drugs did not belong to anyone else. Is that correct?
All that I can verify is that she was in possession of the drug.
If those drugs actually belonged to the owner of that vehicle and left them in there, could you invalidate that assumption?
She would still be in possession based on the sole occupant of the vehicle.
I mean, that's your opinion.
That's the facts of the case.
I mean, the jury is the final facts. That's not for me, you or the jury, that's for the jury, but.
That's the facts of the case.
Is that a fact?
That is a fact that she was in possession of the controlled substance, yes.
It's a fact that you charged her.
Yes.
If this jury can give her an acquittal, that won't be a fact that she possessed it. Is that correct?
Objection, argument.
Withdraw the question. No further question.
You ready?
It's not your opinion whether or not she was in possession of those edibles, correct?
Correct.
And that's the law, right?
Correct.
So the law is, tell the jurors what the law is about possession when you're the sole occupant.
It's constructive possession or sole constructive possession. There's an item inside the vehicle that only she can possess or obtain inside the vehicle. So even if she's saying that she borrowed the vehicle, it is still in the vehicle, with only her in it. She's in possession of it. Whether she's consumed it or not, it's still possession, not consumption.
And she's presumed to have knowledge of what is in the vehicle that she's driving and operating, correct?
That's correct.
Doesn't matter if it's her car or not. Even though there is evidence by her own admission that she did have knowledge that those edibles were in the vehicle.
Correct.
Those are my questions, Judge.
Left out a few key facts on. One is that the law is that constructive possession, you must prove knowledge.
Judge, I'm gonna object.
Well, I'm gonna overrule because y'all been talking about what the law was for the last 10 minutes, and so you got into it. I'll overrule your objection. Go ahead, Mr. Reynolds.
Knowledge is required. That's the law. And your testimony is that she possessed it because she had knowledge, and she said she had knowledge that it was in the vehicle.
That's correct.
And that's on the video.
It is.
So when the jury go back to the back and watch that video, they're gonna hear her say,
I forgot that was in there.
okay, those are my questions.
Step down, sir. May this witness be excused or?
Yes, Judge.
Yes, Your Honor.
Not need for rebuttal or?
No.
Okay, he's excused. Okay, any
Judge.
other witnesses?
No, Judge, the state rests.
State would rest. Okay. Would y'all approach? All right, ladies and gentlemen, the state has rested, and ordinarily we would put you on break, and there would be motions that would be made for me to rule upon, and you wouldn't hear that. But the parties have agreed for learning purposes that we're going to allow you to hear these motions, or this motion. What you should understand is you should disregard how I rule on the motion, okay? This is not for you to be concerned. It's just a part of the learning process, okay? So, Mr. Reynolds, I understand you have a motion, sir?
Judge, at this time, we motion for an acquittal on the defendant because we feel that the state failed to failed to prove required element to the crime of possession by failing to prove that the defendant had knowledge that the drugs was in the vehicle. The trooper testified that in the video, the defendant admitted to knowing that those drugs was in the video. In my opinion, I did not hear that, Judge, and I don't think that's a fact. So we ask that you render acquittal on the defendant at this time based on based on the state failure to prove the required element of knowledge.
Thank you, Mr. Reynolds. Would you like to respond?
Just quickly, Judge, I do believe there's been sufficient evidence in this case to proceed to the fact finders, to the jury.
Okay.
We would ask for the motion to be denied.
Okay. All right, I'm going to deny your motion for judgment of acquittal. Mr. Reynolds, again, ladies and gentlemen of the jury, you should not take anything from my ruling denying Mr. Reynolds' motion, okay? Because you are the trier of fact, and I will instruct you on the law to apply. But at this stage of the game, I'm denying the motion, all right? So at this time, we're going to go on break. Let me first instruct the jury, because you'll be leaving first. You will be escorted to the jury room by Officer Porter. You will remain in the jury room. There are restrooms in there. You can use your cell phones if you have them, except to research the case, okay? Don't be Googling popcorn or controlled substance or field tests or anything. If I find out that you did it, there will be consequences, okay? There are refreshments in there, restrooms. Don't talk about the case among you. You can talk about anything but the case, all right? So at this time, satisfied with the instruction to the jury counsel?
Yes, Your Honor.
Officer Porter, if you will escort them to the jury room.
All right.
Everybody stand for the jury, please.